appeal in the matter of Denning and others and the Commissioners of Her Majesty's Revenue and Customs?
Yes, Mr. Brinsmead Stockholm, I can tell you that we have read your reading list.
I'm very grateful, my Lord. My Lord, I appear for the appellants, Her Majesty's Revenue and Customs, who I'll refer to as HMRC or the Revenue. My learned friend, Mr. Firth, appears for the respondents, Dr. Denning, and the two companies indirectly wholly owned by Dr. Denning. My Lord,
just in terms of context, so I can understand why we're doing this.
Yes.
The disposals were between connected persons, and therefore they're deemed to be at market value. Is that why we're looking at market value?
It's not quite that, my Lord. Right. It's that there was, we'll come on to look at the documents briefly, but you'll have seen there was a disposal of, that purported to be for goodwill of 1.8 million between the two care homes. The tax provisions work such that if that wasn't really attributable to goodwill, then it will be taxed in a different way. So the taxpayers claim all of that consideration was attributable to goodwill, and that a particular relief applies in respect to that.
Well, I think I would just like to know how the question arises.
Indeed, my Lord. Perhaps if I deal with that in context, would that help?
Yes, it would.
I'm grateful, my Lord. Just to deal with the housekeeping, there should be 3 bundles, so a core, supplementary, and authorities. Are you working from the electronic? I see there are at least 2 laptops.
I'm afraid I'm old-fashioned. I use paper.
So tab numbers would be necessary for references. That may assist my learned friend. Just also to flag, there were updated versions of the skeletons filed at the end of last week. In my case, that's important because the old references were to an earlier version of the supplementary bundle. So as long as we're working from the correct one, that should all flow properly. My Lord, I propose broadly to follow my skeleton. Obviously, I'll elaborate on some points as we go and deal with the arguments that my learned friend has raised in his skeleton. So turning to my skeleton, you've seen paragraphs 1 to 3 by way of introduction. This is a valuation appeal. It's HMRC's appeal relating to the market value of the leasehold interests of 2 care homes in Aldershot, Manor Place and Maple House. Slightly unfortunate that they're both 2 words long and both beginning with M, and it's quite easy to confuse the 2. For our purposes, we don't really need to distinguish between the 2 because the position as a matter of principle is the same. So I'll just refer to them collectively as the care homes. It's HMRC's appeal from the decision of the Lands Chamber. My Lord, the decision, as you have seen, is in core bundle at tab 7. A decision of Mr. Trott and Ms. Martin. HMRC applied for permission to appeal to the Upper Tribunal, were refused, and we'll need to look at the decision refusing permission to some extent in a moment. HMRC then applied for permission to the Court of Appeal and were granted it by Lady Justice Asplin in a permission decision of the 5th of October 2021, and that's behind tab 4 of the Court. And I'll come on to look at some of those documents in due course. In terms of the factual background, again, you'll have seen, my Lord, that almost everything in terms of the facts, and indeed a lot of the principles, are all common ground. We're not really in a factual dispute at all. But it's worth briefly looking at the underlying transactions just so we can put the tax issues in context. Those transactions, the factual position in relation to them is found in the Upper Tribunal decision of paragraphs 3 to 9. I've set out the details in paragraphs 5 to 10 of my skeleton, and we also have the chronology that's in tab 3 of the core bundle, which hopefully will assist when looking at the dates. So starting at paragraph 5, Dr. Denning acquired these 2 care homes, and by 2010 she had acquired a freehold interest in both care homes and was operating them both as a sole trader. 3rd of February 2010 she incorporated the 3 companies. There's a holding company, Jasmine Care Holdings Limited, sitting on top. That's 100% owned by Dr. Denning, and then the 2 respondent companies, MPL and MHL, which are both 100% directly owned subsidiaries of Jasmine Care Holdings, and consequently Dr. Denning was an indirect owner of 100% of the interest in both MHL and MPL. She was also a director of all 3 companies. We get then to the 22nd of March 2011, which is the key date for the purposes of this appeal. That's the date on which Dr. Denning entered into the 3 agreements with each of the companies. So there was 3 agreements with each company, 6 in total. And I've summarised those agreements at paragraph 7. So there was first an agreement for the sale and purchase of the care home businesses as going concerns in consideration for the appropriate book amounts, and including the goodwill of the vendor in connection with the business. And then that agreement also provided that Dr. Denning would grant a lease in the terms that was then granted. So that's the overall assignment agreement. We then have the second agreement, which is the lease itself. That was a grant of a lease over each of the care homes for a term of 5 years at an annual rent without review of £225,000 for Manor Place and £175,000 for Maple House, with no premium payable. And Dr. Denning retained the reversionary freehold interests in the two care homes. And those two leasehold interests are the leasehold interests that we are concerned with and what I've referred to as the leasehold interests in my skeleton. Finally, and in a sense the key document, at least for purposes of tax appeals, there were deeds of assignment of the goodwill of the businesses from Dr. Denning to the two respondent companies for £1.125 million in respect of Manor Place and £675,000 in respect of Maple House. So total consideration for the goodwill of £1.8 million. Now, those agreements are in your bundles. They're in the supplementary bundle at tabs 10 to 12. We've only included the ones for Manor Place because there's no material difference between the ones for Manor Place and Maple House, so to avoid duplication. One point to note, which is a point my lord have already picked up, these were transactions between connected parties. So between Dr. Denning and companies that she indirectly wholly owned and of which she was a director. So these were not transactions at arm's length. So my lord, to turn to your question then, the question as to how the market value of the leasehold interests and the freehold interests feed into the tax treatment. We're obviously not directly concerned with the tax treatment here.
No.
It's only how it reflects in the tax.
Can I just, sorry, just before
Yes,
you
my lord.
can I just, the sale and purchase of the business, which you say is for the appropriate book amount, but including the goodwill in the business, there's no number put onto that sale and purchase agreement. I mean, was there a...
There isn't, my lord. And the position is that aside from the goodwill, there's no dispute about the appropriate book amounts. The only question in the tax appeals will be what, if any, value of goodwill was assigned. And that is covered separately. Well, the specific figure is included in the third agreement. So, as I understand it, the first agreement is an overall agreement providing for the sale, and then the third agreement provides a specific figure in relation to the goodwill. So, my lord, as I outlined a few moments ago, the tax debate essentially concerns those payments made by the two companies in respect of the goodwill. And just for your note, those payments were made through Dr. Denning's loan account with the companies. So, if I could perhaps outline the two different analyses that will be in the tax tribunals. The respondent's position is that that 1.8 million is simply a payment for goodwill of the care home businesses. Dr. Denning filed her tax returns on the basis that she was liable to capital gains tax on that amount, and then claimed entrepreneur's relief in respect of that liability, which reduced the tax liability or the tax rate from 28% to 10% in respect of the gain arising on the disposal of goodwill. In contrast, HMRC's analysis was that the care home businesses had no goodwill to assign, and in consequence, the receipt of the £1.8 million was in fact represented premiums payable by the companies in respect of the leasehold interests up to the value, the market value of the leasehold interests. And then essentially any excess over that amount represented a distribution made by those companies to Dr. Denning under the provisions concerning distributions. So taxable as income at the marginal income tax rate. So to answer your question, well, it's not a formal market value deeming provision. It's simply a question of, in fact, what were these payments for? And the argument would be that if the leasehold interests did have substantial value, then the payment is attributable to those interests rather than goodwill.
Right.
My lord, just to note one other point, as far as the companies are concerned, the relevance here is that if the payments are attributable to leasehold premiums, then that will impact their SDLT liability on the acquisition of the leasehold interest. So that's why they are respondents as well.
So that's a knock-on effect.
Well, that's an additional effect of the leasehold interest having value on HMRC's account. So in summary, the correct tax analysis turns to a significant extent on the market value of both the leasehold interests and the freehold interests. And that's why the tribunal stayed the tax appeals, referred the valuation questions to the Upper Tribunal. Just again for your note, you'll have seen that the freehold interests, the experts before the Upper Tribunal agreed, accepted by the Upper Tribunal, so we're not concerned with that, we're only concerned with the leasehold interests. So, my Lord, turning then to the valuation experts that were before the Upper Tribunal, you'll have seen that the respondents called Mr. Mark Ellis, and HMRC called Ms. Vanessa Rodriguez, and each expert produced 2 sets of reports simultaneously. So there's an initial report and then a response, and then they produced a joint report. So you can find all of those reports in the supplementary bundle, tabs 1 to 6. You've also seen in the Upper Tribunal decision that in agreeing, in performing the exercise of valuing the leasehold interests in the care homes, I need to be slightly careful because, as you'll have appreciated, there is a dispute as to exactly what they were valuing. But at least in terms of addressing the issue before the Upper Tribunal, the experts agreed almost all the relevant valuation principles, the figures to be used, and indeed the final valuations. In a sense, the only disagreement between them is to what they were actually valuing.
Yeah, as the UT said, they are asking them, the UT, to explain what they'd agreed.
Indeed, and then says it can't tell them, which arguably it did need to. But, my Lord, in terms of those points of common ground, those are set out in the Upper Tribunal decision at paragraph 10, and it lists them there. My Lord, I've set them out in paragraphs 12 to 18 and summarised them under 5 key points of agreement. Perhaps if I could take you through those and just take you to the relevant key concepts that we need to
Well, just pause a moment.
Yes,
Somewhere, I think, the expert said that the rents were at the lower end of the potential range, but they nonetheless adopted them.
That is right, my Lord.
Which I don't think comes into paragraph 10, does it? Unless I've missed it.
No, it's 10.6. He talks about it being a market rental value that was agreed.
Yeah. Yes, that's right. It was agreed, was represented by the passing rents. That's not quite right in terms of what was agreed. They agreed it was at the lower end, but within valuation tolerances, and it was reasonable to adopt.
Indeed, and there were 2 aspects for which that was true. There was both the rent, the passing rent, and whether that reflected a market rent. Also, the year's purchase figure, which is the multiplier that they used.
They compromised on that.
They did. So there was, effectively they compromised. They still maintained that they disagreed, but they were prepared to say 2.125 was an acceptable figure. So, turning to those areas of agreement, and in the process of doing that, looking at some of the key concepts that we will need to consider. The first point is they agreed the relevant valuation date, so it's the day of the transaction.
Sorry, say that again?
Sorry, my Lord. The day of the transaction is the relevant valuation date,
yes.
So 22nd of March, 2011. Second, and more importantly, both experts agreed the general approach to valuation of these interests, and that involved a number of aspects. So the first point was that each care home was to be valued as a trade-related property, applying the relevant RICS guidance. Now, my Lord, you'll have seen that there was a disagreement as to what the relevant RICS guidance was. Mr. Ellis, for the taxpayer, said it was what's referred to as Guidance Note 1 from 2010, from the 6th edition of the Red Book. I'll refer to that as GN1. That is in tab 7 of the supplementary bundle. Ms. Rodriguez, in contrast, referred to the Global Standards Valuation Practice Guidance Application 4, or VPGA 4, which was the version in force in January 2020. I should say there are duplicate copies of those in the authorities bundle, so you can just ignore those. I'll refer to the ones in the supplementary bundle. But VPGA 4, the version referred to by HMRC, was the current guidance at the time of the Upper Tribunal hearing, and the Upper Tribunal at paragraph 96 held that it was appropriate to focus on BPGA 4. I quote, "The valuations were prepared for this hearing and should therefore reflect the guidance in force at the time we considered the matter." I submit that was entirely correct for the reasons that the Upper Tribunal gave. But, my Lord, it's important to note that, and we'll come on to see, that the Upper Tribunal also had regard to GN1, the earlier superseded guidance, in a way that was actually fundamental to the decision and the result that it arrived at. In any event, both experts agreed that the RICS guidance applied and that these care homes were trade-related properties. So we need to look at the definition of trade-related property. My Lord, I should say both experts, in terms of the definitions of concepts, used the definitions in VPGA 4. So that's all I'm going to refer to for these purposes. The definition of trade-related property is in the supplementary bundle at it's tab 8, page 209. Paragraph 2.12, trade-related property. This is any type of real property designed or adapted for a specific type of business where the property value reflects the trading potential for that business. I note in passing the focus on property and property value. Now, because the experts agreed that these were trade-related properties, they also agreed that they had to be valued on the basis of the profits method. And that's recorded in paragraph 10.2 of the Upper Tribunal decision. They also agreed that profits method required them as valuers to assess figures for fair maintainable trade, or FMT, and fair maintainable operating profit, or FMOP. Now, those are hypothetical figures arrived at on the basis that the trade-related...
It's actually fair maintainable turnover, isn't it?
Well, it's
they got it wrong. It's
well,
turnover, isn't it?
Well, sorry, I should say in the earlier version it's fair maintainable trade. In this version it's fair maintainable turnover. Yes, so in BPGA 4 it's turnover. They come to the same thing. But you're right, my Lord, yes.
But turnover is a rather better word because it tells you what it really is.
Indeed, indeed. My Lord, those are hypothetical figures arrived at on the basis that the trade-related property was operated by what is referred to as a reasonably efficient operator, an REO. So again, a hypothetical construct. And we should turn to those definitions. First of all, the REO, that's in the same tab over the page, page 209. My Lord, if I could, it's paragraph 2.10. If I could ask you to read that.
Yeah. Yes.
My Lord. So the FMT and FMOP are determined by reference to this hypothetical construct of the reasonably efficient operator. You'll note in that definition that it excludes personal goodwill. Personal goodwill is defined in the paragraph above that. So if I could just ask you to read that as well. It says personal goodwill of the current operator. So whereas the REO is a hypothetical construct, the personal goodwill relates to the actual business operating on the ground at the time. Well, there's one other paragraph in this context we should look at, page 211, so forward 2 pages. Paragraph 6.3.
Yeah.
So, my Lord, what the valuer is enjoined to do is to exclude any value attributable to personal goodwill, but to include any additional value that an REO would be able to generate over and above that which the current business is generating.
How do you take into account goodwill, just looking at that, personal goodwill? Assuming you have a business which is conducted by people, and the people transfer on sale of the business.
So, my Lord, the answer is that because this guidance is dealing with valuation of land, the answer would be that any goodwill attributable to those people would not be included in a valuation generated from this guidance. That's why it says you should exclude personal goodwill. So personal goodwill, in your example, my lord, would be goodwill attributable to the people. So one example that's sometimes given is if you had a celebrity chef in a restaurant,
Yeah.
and you were buying the restaurant, you wouldn't attribute the value attributable to the
But I'm just looking at the definition in 2.9 for a second, because it says it's the value of the profit generated over and above market expectations. I'm not quite sure what that means. That would be extinguished on sale on the trade-related property. But if you transfer the business with the people, why is that extinguished? Because if you're selling a trade-related property.
My lord, I think the answer is that what it's saying is that it doesn't transfer with the property. It doesn't mean it's extinguished absolutely. It just means that if you transferred the property, you wouldn't.
You mean you transfer the property alone?
Indeed.
And the people didn't transfer with
Indeed.
the property?
Yeah, exactly. So you would exclude any goodwill attributable to those people.
In other words, you're transferring the property, not the property and the business.
Indeed. Indeed, my lord. And this is to do with valuing the property,
Yeah, so
not the property and the business.
it's just not very well expressed. I mean, you've said what I would have expected you to say. It's just that I found it difficult to work 2.9 to achieve. It's just not very well expressed, I think.
My lord, there is a
It
passage
doesn't
in this
matter.
guidance which I can't immediately put my finger on, which does, from memory, specifically say that it is talking about not that it's extinguished completely, but that it doesn't pass. But it probably isn't efficient to try and find it now. Perhaps I can dig it out in the shorter journal. Just one point on that, then, my lord, relating to personal goodwill. It's clear that personal goodwill can be transferred in exactly the way that you've just described. So goodwill in a business clearly can be transferred.
The personal goodwill of a corporate business is everything to do with the company. In other words, it's the branding, it's
IP,
the people it's
brand.
employed,
Indeed.
the systems, all of which generally do transfer on a business sale because of duty and the like.
Indeed. The point here is, as I
You
hope
exclude
I
that because you're
you
dealing
exclude
with property.
indeed, because this is to do with valuing the land.
Yeah.
So, my lord, in my submission, it's important to note that both FMT and FMOP are hypothetical figures. So they're the turnover and profit that will be generated by this hypothetical REO, and there is no necessary link at all between those figures and the business being carried on from the trade-related property at the time of valuation. So, my lord, we can see that in a few paragraphs. If we turn first to 2.2 and 2.23, those are on page 208, same tab.
Sorry, which paragraphs?
2.2 and 2.3, my lord. If I could ask you to read those.
Yeah. Yes.
So 2.2, the accounts give guidance as to what the FMOP might be, but it can clearly be changed. And 2.3 specifically says it may be different to the valuer's estimated FMOP. We also saw in the definition of reasonably efficient operator that it involves estimating the trading potential rather than adopting the actual level of trade under the existing ownership. So that's the valuation method that was agreed. Third point is that they agreed all of the relevant figures for this profits method of valuation. So we've seen, and my lord, you've seen the decision, they agreed figures of FMT and FMOP. They agreed that the passing rents under the leases were within an acceptable range for the market annual rent, and I'll come on to address the significance of that later in my submissions. They also agreed that it was necessary to calculate a figure of FMOP after rent. So having taken the FMOP figure and deducted rent. So in effect, calculating the true operating profit of an REO on a leasehold basis, so the basis we had here. And I've summarised all those figures in paragraph 15 of the skeleton. Point 4 of their agreement, or their common ground, was that they agreed it was necessary to capitalise the figure, or the figures, that were arrived at for FMOP.
Can I just go back for a moment to paragraph 2.4?
Yes, my lord.
Help me with this. fair maintainable operating profit. This is the level of profit stated prior to depreciation and finance costs relating to the asset itself and rent if leasehold. What does that mean?
Indeed, my lord. Well, my learned friend relies on those words.
The value was agreed that you had to deduct the rent.
They did, in the exercise that they did. And so my learned friend says that means that what they were doing was outside this guidance.
Outside this guidance note.
Indeed. But what is clear is that both experts agreed that in the process they were engaged in, they did have to do this exercise. This is certainly the exercise that they did. So in capitalising that figure of FMOT after rent, which we'll come on to see in the joint statement is referred to as leasehold FMOT, they had to arrive at a year's purchase figure. I've already addressed with you, my lord, there was a slight disagreement there.
Because what they were trying to do was not assess the market rent, but assess a capital value.
Indeed. Yes, my lord.
And para 2.4 is primarily aimed at market rent assessment, which you get in step 4C of the valuation.
Indeed, my lord. Yes, that's right. So they were arriving at a capital value. Ms. Rodriguez said for the leasehold interests, and Mr. Ellis said for the goodwill. Now, we'll just flag at this stage, it is an important point that the year's purchase figure is less than half of the 5-year term of the lease. So I'll return to the significance of that point later, but just to flag at this stage that it is a figure considerably less than the full term of the lease. Now, applying that YP figure...
Well, that's because it's got nothing to do with the term of the lease as such. It's to do with a multiplier in this sort of valuation is to do with, as it were, the stability of the business, the predictability of the income stream.
Indeed, my lord. It's to do with, Ms. Rodriguez, I think, put it in terms of it's to do with the risks and reward and the timing of the income that can be generated from the land. So it is a figure of...
Yeah, I mean, when you're valuing a business which doesn't necessarily have anything to do with a piece of property, you use a maintainable earnings with a multiplier.
Indeed. Here, because the income is generated from the land, because the trading potential is seen as being inherent in the land because of its specific adaptation to that trade, what you're doing is, it's exactly the same, capitalising an income stream. But, my lord, you'll have seen that there is an argument put to me that HMRC's position is that, or leads to the conclusion that market rent should be equal to FMOT, i.e. the total operating profit every year. That's not HMRC's position. HMRC's position is that you are still dividing the trading potential as between the landlord and the tenant, but you're doing it in respect to the capital value as well as the annual rental figure.
As a matter of interest, were these leases protected by Part 2 of the Landlord and Tenant Act 1954?
So I'm straying somewhat out of my area of expertise there, my lord. Both valuers proceeded on the basis that they were subject to protection by the Landlord and Tenant Act and that there was a reasonable prospect of continuance.
Renewal. Yeah.
So it may well have been that they went on for longer than 5 years, and to some extent that was one aspect of the disagreement for the multiplier, because clearly if it's potentially a much longer period, the income that could be generated from the land would be significantly higher year's purchase figure. On a final point, both experts agreed that it was necessary... Sorry.
Yes, but the fair maintainable operating profit and the use of a multiplier is actually looking at the income from the business, isn't it?
Well, no, my lord. In a sense, that goes to the very
Well,
heart.
yeah,
It goes from the hypothetical business that could be operated from the land.
Yeah.
And HMRC's case is that is a metric for valuing the land. Now, if you have the land for a longer period, you'd be generating that income stream from the land for longer. So you would have a higher YP figure.
You would use the same method, you say, whether there had or hadn't been a business operating on the property. Let's suppose Dr. Denning granted these leases as startups to her various companies. You would still use the same method. You might have different figures, but you would still use the same method.
Absolutely, my lord. And it's addressed in the evidence, and I'll perhaps come on to it. But there was some discussion of the difference between a warm start and a cold start. And a purchaser in the open market for a non-operating care home would, well, let's say the estimated FMOT would be likely to be lower because you don't know the level of trade, or you have much less sense of the level of trade. There's also much more risk, obviously, inherent in the estimation process. So, my lord, applying that multiplier, the experts came to what they referred to as midpoint capital values for the leasehold interests of 860,000 for Manor Place and 660,000 for Maple House. Final stage in the process was that both experts agreed that it was necessary to deduct the value of the trade inventory from the midpoint capital values for the leasehold interests. And they agreed the values of the trading inventory, 130,000 for Manor Place and 117,500 for Maple House. So after performing that exercise, all of which was agreed, they arrived at figures which they referred to as the capital values for the leasehold interests, less the trade inventory, of 730,000 for Manor Place and 542,500 for Maple House. And that's what I've referred to as the agreed valuations. So we can see, my lord, the whole valuation process was agreed by both experts. Both experts agreed that the leasehold care homes, and I'll use that as a neutral phrase rather than referring to the leasehold interests, because clearly that's my case, valued as trade-related properties, had significant value. They agreed how to arrive at that value, and they agreed what those values were.
And your case, presumably, is that if we are with you, then we simply substitute the figures in paragraph 10.9 for the nil, which the Upper Tribunal.
Indeed, my lord, yes, absolutely. So, my lord, we've already established then that the sole issue is the value of the leasehold interests. There's no dispute here as to the meaning of market value. And there's no dispute either as to the meaning of the open market. In my submission, the Upper Tribunal correctly recognised that the issue in dispute reduces to the question, what do the agreed valuations of the experts represent? And that's paragraph 91. And the Upper Tribunal set out the competing analyses of both sides in paragraph 16. And perhaps if we can just go to that in the Upper Tribunal decision, because that does summarise the two cases that were put to the Upper Tribunal very well. It's page 8, it's tab 7, page 86, my lord. There is a continuing dispute about what is comprised in the value of each leasehold interest. I.e., the appellant says that the value of the leasehold interest is restricted to the value of the right to occupy the property at the agreed rent, and that the figure which the valuers have agreed as the capital value of the leasehold interest relates solely to the value of the business goodwill. The respondent argues that the value of the leasehold interest comprises the value of the right to occupy the property at the agreed rent plus the agreed capital value, the latter reflecting the trading potential of the trade-related property and not goodwill. In my submission, that accurately summarises the debate, but there is another way of framing the debate, which goes to the question of what the nature of trading potential is in these contexts and in the context of this guidance. Now, it's common ground, I don't understand it to be disputed, that the agreed valuations do represent trading potential. And that trading potential has been capitalised, as we've seen, using a year's purchase figure. For your note, that's in the joint report at 2.8.2 and 2.8.4. It's also recorded in the Upper Tribunal decision at paragraph 117.
Paragraph?
117, my lord. If we briefly look at the joint report, so that's in the supplementary bundle at 2.8.2, and it's page 196. Sorry, 195. This is in the section Matters of Disagreement. 2.8.2 sets out Ms. Rodriguez's position, maintains that it is clear from the applicable RICS guidance that the trading potential of the two properties, the calculation of which is agreed between VR and ME, as set out in sections 2.5 and 2.6. There's the earlier section setting out all the figures. And then over the page in 2.8.4, which is setting out Mr. Ellis's position, the basis of his disagreement, top of that page, indeed in the subject cases, assessments of the trading potential have been agreed. So it's clear that both sides agreed that what they'd arrived at was a valuation of trading potential. So we need then to see what trading potential is in this context, and that is in VPGA 4, again, tab 8, page 209. Paragraph 2.13. I wonder if I could ask you to read that.
Sorry, can you give me the reference?
Of course, my lord. It's page 209, the supplementary bundle, and it's 2.13, definition of trading potential.
Do you have a problem here, Mr. Brinsmead Stockham? You said in your grounds of appeal that the Upper Tribunal had wrongly interpreted this guidance note, but you didn't get permission.
My lord, I'm going to come on to my specific grounds of appeal. My ground of appeal is that the Upper Tribunal was wrong to attribute the valuation to goodwill, and that is an error of law.
Yeah. And is it? You say it's open to you to make that good by reference to the proper interpretation of VGPA 4?
Well, I need to set out. I also need to set out my positive case and my reasons as to why I say our analysis is correct. I'm going to come on to do that, and then I will demonstrate, hopefully, why there is an error of law in the Upper Tribunal decision.
Right.
But plainly, the Upper Tribunal was proceeding on the basis of this guidance, so it's at least relevant to look at it. It may not be sufficient to ground an error of law on its own. Well, my lord, you'll see there, and in my submission, this definition is important. And you'll see that it refers to trading potential as the future profit that would be generated by an REO, and says it reflects a range of factors that are inherent to the property asset. And I'll come on to the significance of that in a moment. But in short, in my submission, the issue that was before the Upper Tribunal was whether the agreed valuations relate to the leasehold interests or do they relate to a separate and distinct asset of goodwill. And in my submission, that is a dispute as to the nature of the assets that are subject, that were the subject of the experts' agreed valuations. And in my submission, that question, what is the nature of the asset that's being valued here, are these valuations ascribable to goodwill or to the land? That is a question of law. Because the question as to whether goodwill exists and whether the Upper Tribunal has applied the correct test to identify goodwill, in my submission, is plainly a question of law. And Lady Justice Asplin, in her permission decision, recognised that that was the legal issue with which this appeal court was concerned. So turning then, my lord, to the Upper Tribunal's decision, the analysis of the Upper Tribunal is in paragraphs 91 to 122. Now, the first point to note, my lord, is that paragraph 91, a paragraph that we've already referred to, the Upper Tribunal accepts what I've referred to as the agreed valuations. It says, well, these are the valuations the experts have agreed. The only question is, what do they relate to? So there is no dispute in this case that these care homes, on the arrangements that were set up, had value, had capital value. And that, as we've seen, was agreed between the experts, and there was no basis on which to challenge that agreement. But the Upper Tribunal went on to hold that those agreed valuations related to a form of business goodwill, and specifically what it referred to as transferable goodwill. Now, the key paragraph of the Upper Tribunal decision in that regard, in my submission, is paragraph 117. And that's at page 105, my lord. If I could ask you to read that paragraph.
It really all stems from paragraph 109. They say, look, we've got leases at market rents here, and yet the value is agreed that a premium would be paid. So what can it be? Well, it can't be the leases because they're at market value. So it must be something else. What is that something else? It's transferable goodwill. That seems to me to be the reasoning process.
Well, what they're presented with is a valuation that's agreed, and there are two opposing analyses.
Yeah.
The Upper Tribunal plainly plumps for the analysis of goodwill. My submission is, if that conclusion is wrong, and that's clearly a very material aspect of the decision, indeed, I would go so far as to submit that if that is wrong, it's not attributable to goodwill. The only alternative is the leasehold interests.
Yeah.
That's the only thing that's been identified as the possible locus for this value. But indeed, my lord, that's the tribunal setting up the debate. Absolutely. My lord, I would just note 2 points about 117 because this is the key finding in relation to transferable goodwill in my submission. First point to note, and just to refer back to a point I've already made, they do say that this is all to do with trading potential. So the trading potential of Manor Place and Maple House that's reflected in the agreed valuations. So this is the Upper Tribunal finding that the agreed valuations reflect trading potential. There is one point about this paragraph that's a little unclear. It does say that those valuations, i.e. the agreed valuations, must also include transferable goodwill. It's not entirely clear what that refers to. It's clearly not the Upper Tribunal saying that part of what I have referred to as the agreed valuations, i.e. the capital figures that we've looked at, are attributable to the leasehold interests. We know that because the Upper Tribunal says they have a value of nil. My submission, the better reading of those words is that when the Upper Tribunal is referring to the agreed valuations here, it's talking about both the market rent and the premium figures. And you can see at paragraph 91, paragraph we've already looked at, the Upper Tribunal says that the experts have agreed the market rent and have ostensibly also agreed the market value of the leasehold interests. And when you read 117 in light of that, what the Upper Tribunal is saying in 117 is that the market rent is attributable to the leasehold interests, and the rest of the value, i.e. the agreed valuations, are attributable to transferable goodwill. So my submission 117 is the Upper Tribunal finding that the whole of the agreed valuations are attributable to this concept it identifies of transferable goodwill. And in finding that, it was simply accepting the taxpayer's case that it had outlined in paragraph 16, that these agreed valuations related to goodwill. Final point on 117, the form of that business goodwill, the Upper Tribunal specifically says, is what it refers to as transferable goodwill. We'll come on to see that's a concept derived from GN1. But that's what it hangs its hat on. My lord, the Upper Tribunal permission decision then clarified two aspects of the Upper Tribunal's decision.
So can we just pause for a moment on 118?
Yes, my lord.
Where they say the subdivision of goodwill into different types is no longer considered helpful. But VGPA 4 unquestionably does divide goodwill by excluding personal goodwill from something else.
Well, my lord, with respect, it doesn't, because what it doesn't refer to is any other kind of goodwill.
No, it doesn't, but you have to exclude personal goodwill.
Indeed, my lord.
And here the Upper Tribunal seem to be saying, well, goodwill is goodwill, and there's nothing.
I would certainly endorse the analysis that goodwill is goodwill and one shouldn't seek to slice and dice goodwill. The important point in my submission, one of the important points, is that in VPGA4, the value attributable to trading potential is not described at all as being goodwill. The earlier versions of the RICS guidance did refer to it in that way. Yes. And Ms. Rodriguez had said, well, that was changed because it was considered to be unhelpful, which clearly it was, because in my submission, that's why we're here today. But the only reference, or there is no reference to the value of trading potential as being a form of goodwill at all. So the earlier slicing and dicing that had gone on in GN1 is not in VPGA4. My lord, if I could ask you then just to turn to the permission decision of the Upper Tribunal. That is at page 113 of the core And that helpfully clarifies some aspects of the Upper Tribunal decision. The first was in the Upper Tribunal's response to HMRC's ground 3. And if I could just ask you to read from, so bottom paragraph of page 113, from Ms. Rodriguez. So my submission, my lord, the Upper Tribunal making clear that it had found that transferable goodwill was a separate asset from the leasehold interests, and rejecting Ms. Rodriguez's analysis to the contrary, albeit Ms. Rodriguez had referred to trading potential. She didn't refer to transferable goodwill because that isn't a term in the guidance she was relying on. Second clarification is in respect of ground 1. And there HMRC had said, well, that there seems to be a tension in the Upper Tribunal decision, in that in some instances it's referring to the actual business operating on the land, and in some instances it appears to be referring to a hypothetical REM. And we'd said, well, that's an error of law in the decision. And the Upper Tribunal there clarifies that in arriving at its conclusion, the Tribunal was not considering the actual business, but that of a hypothetical REO.
Yeah.
Just to flag one, probably the clearest instance of that lack of clarity that we had identified in our application, that's at paragraph 106, which is on page 103. And there, as the name suggests, the profit method is concerned with the trading potential of the property being valued. And in this case, we need to consider whether the premium resulting from its application, excluding any personal goodwill, is solely indicative of the trading potential inherent in the leasehold interest, or whether it also reflects other trading potential originating from the business conducted on the property. Now, we had submitted that it appeared that that was a reference to the actual business operating on the property. The Upper Tribunal has clarified, no, it's considering only the hypothetical business of an REO, which, as we've seen, is in line with the guidance. Now, in my submission, my lord, paragraph 117 that we've just looked at, that is the critical conclusion of the Upper Tribunal. Because what it is doing there is finding that the agreed valuations are attributable to transferable goodwill as a separate and distinct asset. It follows from that the agreed valuations were not attributable to the leasehold interests. It follows from that the leasehold interests have no value. And in my submission, that is the fundamental basis of the Upper Tribunal decision. And as I've said, it's important to bear in mind in this context that the Upper Tribunal was presented by both experts with a capital value for these care homes. There were only two options put forward, goodwill or leasehold interests. It was a binary choice for the Upper Tribunal, as it identified actually in the transcript. And in my submission, it follows that one recurring argument in the respondent's case that's repeated at numerous points in Malone Friend's skeleton argument is not correct. Malone Friend seeks to say that the question of whether the agreed valuations represent goodwill is effectively irrelevant. But in my submission, that's not right. The conclusion that the value was attributable to goodwill is fundamental and is the fundamental basis of the Upper Tribunal decision. And if that conclusion involved an error of law, such that the agreed valuations are not attributable to transferable goodwill, then, as I've already submitted, it would follow that those agreed valuations are attributable to the leasehold interests. Because as we've seen, there's no other locus that's been suggested for that value. And it would be, the Court of Appeal would be entitled in my submission to remake the decision on that basis. Now, at one point in Malone Friend's skeleton argument, he does seek fleetingly to attempt a third possibility, or a third way of what the agreed valuations could represent. That's at paragraph 85 of Malone Friend's skeleton. And it said, if HMRC are right about this point, that is that the agreed valuations did not relate to goodwill, it will simply mean that the calculated premium does not accurately reflect the value of any asset and the goodwill would have to be valued in accordance with whatever the correct methodology for valuing goodwill is. But in my submission, that is not a real alternative, because here both experts agreed, and the Upper Tribunal endorsed, the capital valuations they came to of these leasehold care homes. And in my submission, it's untenable to suggest that the agreed valuations do not accurately reflect the value of any asset, where that's contrary to the views of both experts in the case. I'd note in passing that the respondent's argument in that regard is quite surprising, because it was the respondent's case before the Upper Tribunal that the agreed valuations did relate to goodwill. And having succeeded on that basis, they now seek to maintain that the issue is irrelevant, or as an alternative, to simply disavow the valuation agreed by both experts. My submission, in fact, this argument is essentially seeking to ignore the fact that both experts agreed that under the arrangements that were put in place, the leasehold care homes did have substantial value. And that is a fact of central importance to the case. So I submit that is the main strand, the goodwill strand is the main strand, the most important strand of the Upper Tribunal's reasoning. I do also need to look at the other strand in the reasoning, and that is, my lord, as you've identified, that the experts agreed that the passing rent under the leases was a market annual rent, and that it necessarily follows that the leasehold interests have no value.
Yeah.
Now I've set out the relevant paragraphs. In my submission, it's paragraph 109 to 111 in the skeleton, and that now appears essentially to be the respondent's case. Paragraph 19 of the skeleton, of skeleton, it says the basis for disputing HMRC's assessments was that in essence the leases were at market rents and therefore had nil value. Now I'll obviously need to come on to address that argument, and I will do that. But I have done that in paragraph 44 to 54 of the skeleton. I'll make submissions on that in due course. So, my lord, what I propose to do first of all is to set out HMRC's positive case, why I say the analysis that these agreed valuations relate to leasehold interests is correct, and then I'll identify the errors of law. But in putting that positive case, hopefully it will frame the debate and also explain the principal basis for HMRC's analysis. And perhaps more importantly, if I am able to demonstrate that there is an error of law in the Upper Tribunal's decision, it will then allow the court to endorse HMRC's analysis. So it's not the purpose of this section to specifically identify errors of law in the decision of the Upper Tribunal. It's instead to put the principal basis for HMRC's analysis. Now, I'll keep it relatively short because obviously the focus needs to be on the Upper Tribunal decision, but it's important to see that analysis in the light of what HMRC is saying. So, my lord, the way I've put it in the skeleton is to say that HMRC's analysis in my submission is correct both on the clear terms of the RICS guidance and also as a matter of general principle when you're looking at a profits method valuation. So turning first to the RICS guidance, we've seen that both experts applied the RICS guidance and the Upper Tribunal held that it was appropriate to focus on the terms of VPGA 4. Now, in my submission, numerous passages in VPGA 4 make clear that the trading potential forms part of the value of the trade-related property as an interest in land. So there are a couple of passages I would take you to. The first is paragraphs 1.2 to 1.3, which are on page 207.
Can you say this is open to you in terms of the permission to appeal you've got?
My lord, this is me setting out HMRC's analysis of what the right analysis is. Right. I do still need to go on to show why the Upper Tribunal are wrong. In my submission, it's easier to see why they're wrong once you've seen what my analysis is.
But you said a moment ago that you've got two strands to this. One is to look at the RICS guidance, and the second is a matter of principle.
Yes, my lord.
I'm slightly curious as to why, given what the Lord's just put to you, you don't start with principle.
I'm very happy to start with a point of principle. I mean, they're just...
I'm just curious as to why you head straight away into potentially difficult territory, as opposed to just dealing with a point of principle first.
Well, I think the point of principle is somewhat more abstract. The RICS guidance is very clear. Both experts agreed it applied. And in my submission, the point is that if you identify an error of law in the Upper Tribunal decision, then it is open to you to remake that decision and to make any findings of fact that were open to the Upper Tribunal. My submission, you will, in doing that, want to see what the relevant bits of the RICS guidance and why I say That's what the Upper Tribunal should have found. My Lord, I'm very happy to do the web principle first, but they're both relatively brief. I've probably taken longer explaining why I'm doing it in this order than I will to actually get
Well, you take the order that you want. But,
well, Lord, if you find an error of law in the Upper Tribunal decision, you are then in the position of the Upper Tribunal to remake the decision.
Yeah.
So you will want to see the relevant RICS guidance, which the Upper Tribunal did rely on. And in my submission, that points very clearly in favour of HMRC's case.
Right.
So it's page 207 of the supplementary bundle. And if I could ask you to read 1.2 and 1.3.
Yeah.
My Lord, also, just for your note, paragraph 2.12, which I've already taken you to, which is the definition of trade-related property. In my submission, these passages of VPGA 4 make it clear that the guidance which the Upper Tribunal held to apply was concerned with and only with the valuation of TRPs, trade-related properties, as properties. So we've seen the reference to the value of the property interest in 1.3, and that such valuation reflects or is made on the basis of trading potential. My submission, VPGA 4 is clear that the TRP is valued on the basis of trading potential.
And that's what Mr. Trott himself said in Mohammed. He said it was intrinsically linked.
He did. That Mohammed is perhaps a case we can come on to. We'll see that the passage that Mr. Trott relied on, where he goes on to refer to a Privy Council case, he does actually specifically refer to the whole process going to the value of the land in paragraph 79.
But indeed, he distinguishes there between open market value and worth to owner.
Indeed, and says open market, it can never be lower than open market value, but it can be higher, in effect, if you have personal goodwill.
Yeah.
Now, the Upper Tribunal notes, my Lord, in paragraph 112, that VPGA 4 says you must value on the basis of trading potential. And it goes on to say, but nowhere in any of the RICS guidance does it say that such trading potential is exclusively and wholly reflected in the value of the interest in land. Now, in my submission, VPGA 4 is very clearly and expressly the RICS guidance about valuing property. And it repeatedly refers, as we've seen, to trade-related properties being valued on the basis of trading potential. There is no suggestion anywhere in the guidance that trading potential goes to anything other than the value of the property. And certainly nothing to say that it goes to the value of a separate asset of goodwill. And it's worth noting in that context, paragraphs 7.1 and 7.2 of VPGA 4.
7.1 and 7.2?
Indeed, my Lord, it's page 212. My Lord. Now there, what is being said, my Lord, is that even an empty property you value on the basis of trading potential. Now, the figure will be lower, but you're still valuing it on the basis of trading potential. In my submission, again, the empty property, there can be no goodwill. There is no business there at all. And yet the guidance is saying you value the property by reference to the trading potential. So my submission, it's clear from those passages that trading potential relates to the value of the land. But the clearest statement of all is one that we've already looked at, which is paragraph 2.13 of the guidance, which is the definition of trading potential itself. And we've seen there, my Lord, that it says expressly, trading potential reflects a range of factors, such as the location, design and character, level of adaptation, and trading history of the property within the market conditions prevailing that are inherent to the property itself. Again, in my submission, if it reflects factors that are inherent to the property itself, it must go to the value and only to the value of the property. Now, again, the Upper Tribunal addresses this point at paragraph 116. It says the definition of trading potential contained in VPGA 4 says it is further profit that reflects a range of factors that are inherent to the property asset, but the definition does not state in terms that trading potential is only comprised in such factors. But in my submission, no such statement in terms is required. Trading potential is expressly defined to reflect a range of factors that are inherent to the property. There's no suggestion, again, anywhere that it reflects any other factors that are somehow not inherent to the property asset. Moreover, we've seen that there is a separate concept in the guidance of personal goodwill that concerns value that is attributable to the specific guidance operating from the trade-related property on the date of valuation. And that's in contrast to the value that's attributable to factors that are inherent to the property asset.
I mean, this is all because the trading potential is the trading potential that a reasonably efficient operator, a hypothetical reasonably efficient operator, can generate, and that it necessarily excludes personal goodwill.
That's right, my lord. But what in my submission the guidance is saying is that if this value is inherent in the land, if it can be generated by a reasonably efficient operator, then that is value you attribute to the land.
Yeah, because you stripped out by the concept of reasonably efficient operator anything which is goodwill not attributable to the land, i.e. personal goodwill.
Absolutely, my lord, yes. Now, but what's important is that the goodwill, and we'll come on to see this, but the goodwill that the Upper Tribunal refers to is transferable goodwill. That is a concept that has been dropped from VPGA4 and instead is referred to as trading potential.
But when transferable goodwill was in Guidance Note 1, it was alongside and in distinction to personal goodwill.
It was, but it was also said to be inherent to the land.
Yes.
So,
I'm not making a point against you.
oh, I'm sorry, my lord. Yes, well, perhaps I agree, absolutely. There is the distinction it's drawing between personal and transferable. My point is simply that transferable goodwill, as was referred to in GN1, is inherent to the land. But if that's right, then in my submission it follows that the Upper Tribunal analysis is wrong.
Yeah, that's your argument.
Indeed, yes, my lord. So my submission, So my submission is clear on the basis of the applicable RICS guidance that the agreed valuations, which we've seen were agreed to relate to trading potential, must be taken to be valuing the land, because that's specifically what the guidance provides for. Now, that's the guidance. I've promised a principled analysis, and this will be very short. As we've seen, the trading potential is the future profits to be generated from the TRP, measured by reference to a hypothetical business conducted by a reasonably efficient operator. And in my submission, what that method does is to recognise that those expected future profits would be available to any and every reasonably efficient operator that could operate from the land. And as a result, all participants in the open market to buy the trade-related property would factor those expected future profits of a reasonably efficient operator into the price they would pay for that property. Now, importantly, in my submission, they do that regardless of the performance of the existing business that is on the land. Instead, as we've seen, they're doing that by reference to the expected profits that this hypothetical construct could generate from the property. And in my submission, it follows that it's correct as a matter of principle to regard trading potential as constituting part of the value of land, because what it does is goes to the price that purchasers in the open market would pay for the trade-related property as an interest in that. So to summarise that, in my submission, the agreed valuations represent trading potential, and both the RICS guidance and the principled analysis that I've just briefly set out are clear and lead to the conclusion that trading potential forms part of the value of the trade-related property as property, i.e. as an interest in land. And that's fully in line with HMRC's case and HMRC's analysis. So that explains, hopefully, the principle underlying what HMRC's case is. I do now need to identify at least one error of law that the Upper Tribunal...
I mean, there's a slightly broader point here, isn't there? That I mean, there are various ways of valuing property, but if you're dealing with commercial property, nobody really acquires it except with a view to making a profit out of doing something. If there are enough comparables, as there are in a shop, for instance, you don't need to go to the profit method to value the property. You can say, well, this is a zone A rate for this street, and therefore we adopt that. But if you haven't got comparables, which is what trade-related property is all about, then you've got to arrive at the value of the property by another method. And the profits valuation is simply a method of arriving at a value of the property where you haven't got enough comparables. And it could be discounted cash flow, it could be residual value, there are all sorts of ways, but they're all designed to get to property values.
Yes, absolutely, my lord. I would completely agree with that. The only additional point I'd make is it's not just the lack of comparables, it's also the fact that these properties are specifically designed and adapted to a particular use. So in effect, you can't do an investment basis because you can't say, well, we could turn this into a shop or a hotel, or maybe a hotel, but you have to use them as a care home. So you have to look at the profits that could be generated from that use. But yes, my lord, I absolutely agree with that. So, my lord, turning to the Upper Tribunal's errors of law, I identified two in the skeleton between paragraphs 35 and 54.
Give me the references again. 75, you say?
Sorry, 35.
35.
35 to 50.
Of your skeleton?
Yes, my lord. My lord, the first is attributing the agreed valuations to a separate and distinct asset of transferable goodwill. And the second is, and that's paragraph 117 principally of the decision. And the second is holding that the agreed market rent must fully reflect the trading potential available to the tenant under the terms of the 5-year lease which it was granted. And that's paragraph 110 of the decision. So I'll address each in turn, my lord. Sorry, my wig is...
I mean, is it more... When the Upper Tribunal referred to transferable goodwill in paragraph 117, did they define what they meant by transferable goodwill?
They didn't, my lord, but in my submission they must have been referring to the concept in GN1.
And if they were, I mean, that's the definition you haven't shown us. But if you do get to that, don't you just, why can't you just say that even just looking at that definition, it's manifestly obvious, or it's obvious, that it refers to the property?
I absolutely do say that, my lord. It could be said against me that the concept being referred to is goodwill in some more general sense. It could be said against me, so I want to address that argument as well. But I absolutely would say that if they are referring, and as they expressly do, to transferable goodwill in GN1, that manifestly relates to the property.
Well, they don't anywhere else in their decision give another meaning to the concept of transferable goodwill.
No, my lord, no. They do refer to it being business goodwill as well. So they go on in, I think, paragraph 121. I'm going to find the decision. Yeah, so in 121, they talk about it because in either event, business goodwill was included as part of the trading potential.
Well, yeah, without get distracted by business goodwill, because that's not a defined term anywhere.
No. I mean, my submission is that they are referring to transferable goodwill because they relied on GN1, and in my submission, it's absolutely clear that that concept relates to the land.
Well, that definition is the intangible asset that arises as a result of property-specific name and reputation, customer patronage, location, and similar factors which generate economic benefits. It's inherent to the specialised trading property, and will transfer to a new owner on sale.
Yes, ma'am.
A simple way of putting your argument is, if that's what they meant by transferable goodwill, then paragraph 117, or their decision, must be illogical, because by definition that can only relate to the property.
Yes, my lord, that's right.
I can see why they abandoned the concept of transferable goodwill, because that suggests that it could or could not be transferred, whereas what you're saying is that it is inevitably transferred
It
because
goes
of
with
its
the land.
inherent
Indeed, my
quality.
lord. And that definition does, as my lord has just pointed to, say it's inherent to the property. I think the confusion is not only the use of the word transferable, it's also the use of the word goodwill. Because in my submission, it's clear from the guidance that that value is inherent in the land. It's not some separate asset of goodwill.
Yeah. I mean,
it's
it would have
part of
been
the value of the land.
It would have been better if, on your argument, it would have been better if they'd have simply, as they say in 2.5.1 of Guidance Note 1, if they'd have stuck to the reference to, quotes, inherent goodwill, which did appear in all the previous guidance.
It did. There has been clearly over the history of this guidance, and indeed, I think it's fair to say revenue guidance, there has been difficulty grappling with the concept of goodwill. my submission, the better place we've got to is BPGA 4, where they don't mention it as being goodwill at all. They simply say you value it by reference to trading potential. And that is not a form of goodwill. Or there's no suggestion into BPGA 4 that it's a form of goodwill. My Lord, turning to those two errors, and perhaps I could be much shorter than I would otherwise be by referring to GN1 and saying it's obvious that it's value in land. I will make that point, but there are a few other points I should make as well, just to cover off the arguments that have been canvassed. You have my submission that this finding that it relates to transferable goodwill, or the values relate to transferable goodwill, is the fundamental basis of the decision, and that the Upper Tribunal clearly regarded it as a separate and distinct asset. And we've also seen that the Upper Tribunal was clear that it was referring to this hypothetical business run by an REO. And on that basis, I submit that element of the Upper Tribunal's analysis is wrong for 3 reasons. And as I've set out, that is the central error in the Upper Tribunal decision. The first is a preliminary point, but nonetheless an important one, which is that there's no authority to support the existence of transferable goodwill as a specific type or class of asset, no legal authority, either in the context of trade-related properties or elsewhere. So my submission, the Upper Tribunal, in relying on such a concept, its decision is novel and unsupported by any authority. Now, it's important to be clear what I'm saying there. We've seen the Upper Tribunal decision expressly relies on the existence of transferable goodwill as a concept. And as we've seen, that is a value said to be derived by looking at the profits that would be generated by a hypothetical business. There's no authority to support the existence of that concept. My learned friend, in his skeleton argument, paragraphs 71 to 74, seeks to rebut this point by pointing to authorities establishing the existence of goodwill as an asset. In my submission, that's clearly a different point. I fully accept that goodwill can exist as an asset, an intangible asset. But the point is that there's nothing to support the existence of transferable goodwill, this concept the Upper Tribunal relies on, as a specific type of goodwill. As we've seen, that's expressly what the Upper Tribunal referred to and relied on. Second point, and this is...
if it's the goodwill that attaches to the property or is inherent in the property, then you would accept it. It is an asset, an identifiable asset. But you'd say that proves your case, that they were wrong to think it was something other than goodwill attaching to the inherent in the property.
Well, my lord, I think the only difference I would have there is I wouldn't say it's a goodwill attaching to the property. I would simply say it's an aspect of the value of the property.
It's a quality of the property.
It's a quality or a facet of the property. It's not good. It's not sort of goodwill that's attaching itself to the property. It's simply the value of the property.
Well, in the old days, goodwill was the difference, if you like, between what somebody will pay for a business and the sum of the parts. Because, or some of the asset values, I should say.
Indeed.
So you have to give some concept to bridge the gap.
So
you value the business because you value a business which you are acquiring on the basis you will be prepared to pay for a thing which generate, or a collection of things which generate an income stream. The collection of things consists of a property, some assets attached to or on the property, and some people.
And the residual value, after you've deducted the assets, would be the goodwill.
And the difference between the sum of those parts and what you pay has to be given some term. People say it's goodwill, and if you want to conceptualize it, it's a value of the likelihood that business will be generated from use of those assets. It's generated because people will go back to the people, or the business branded as it is on the premises. That's personal goodwill.
So my lord, that's certainly still the accountancy approach, that you value the assets and then the residual figure is goodwill. You can also, in an accountancy sense, have negative goodwill. So if the assets are worth more than the value of the business as a whole, you would actually have negative goodwill there because the asset value would be worth more than the sum of the whole.
But the other potential bridging factor is that some people just go back to the premises.
Yes, my lord.
Because there's something to do with the premises, inherent in the premises, which attracts business.
Indeed, my lord. And there are cases that refer to inherent goodwill in the property and saying it forms part of the value of the property. My submission would be that isn't the right approach now, in as much as it simply shouldn't be labelled as goodwill. It shouldn't be called inherent goodwill, because it's simply the value of the asset, the land. And the importance of that is, if you come back to the accountancy approach, you're totting up the value of the assets, and the residual figure is goodwill. You should be including the value of the asset here, measured by reference to the profits it can generate, but you should be including the value of the asset as a value of an asset, not as contributing to the goodwill figure. So it's to do with valuing here the leasehold interest, the land, and that's why I say the reference to trading potential is more accurate, because it's really saying it's a method of valuing this asset by reference to the profits it can generate. So what you arrive at is a valuation for the asset. There's no element of goodwill at all. And so that's why I would submit that references to inherent goodwill there are possibly confusing.
Well, maybe, but I mean, it's a trade-related property. The whole point is that you can't do anything else with it.
Indeed, my lord. It probably comes to the same thing. It probably comes to the same thing if you say inherent goodwill is part of the value of the asset. You get the same result.
Well, that's generally what the word inherent means, isn't
it? It is, my lord, yes. All I'm slightly pushing back on is the use of the word goodwill at all. Because in my submission, all you're doing is arriving at the value of the land.
That's only because you want to look at this as a valuer, a property valuer, and I'm perhaps looking at it through the optics of an accountant. But who presumably doesn't feel quite so worried about using the expression goodwill, because that's what's used all the time.
Well, I hope I'm trying to look at it as a lawyer, because ultimately, when we get back to the tax appeal, the question is going to be, is there goodwill here at all? And if it were to be said, well, the value of the land is X, but that includes an element of inherent goodwill, there might then be a debate as to whether that is goodwill to which entrepreneurs' relief can attach. So it is important in my submission that the value here is attributable simply to the leasehold interest, the asset. It's not attributable to goodwill. And that's why the more recent guidance, the BPGA4, in my submission, is to be preferred and is the correct analysis.
I mean, there is a slight confusion of terms here, isn't there? I mean, even if you go back to the Muller case, if goodwill is that which brings in custom, people might go to a pub in Snake Pass because it's the highest pub in England, but that's the factor of its location. It
Indeed.
brings in custom, but that's because of where it is, or it's got a nice view, or whatever it is.
Absolutely. There is a bit of looseness in some of the analysis, and clearly there is a way of conceptualising that, of saying, well, it's to do with generating the profits, therefore it's some form of goodwill, and that, to some extent, that's what leads some of the case law to talk about inherent, adherent, free, goodwill, all these different kinds of goodwill. My submission, the better way of looking at it is to say the location of a pub is something that is inherent in the asset. You value the asset by reference to the profits you can generate from that asset, and the figure that you get is a value for the asset, the land. It's not a value, there's no element of goodwill at all. It's simply the value of the land.
It's only the value of the land because you have decided you can't do anything else with it other than conduct a trade from it, and therefore your method of valuation focuses on the profits from the trade.
Absolutely, yes, absolutely.
So, yeah.
So it's from the hypothetical trade that would be operated from it, indeed, and then you're effectively valuing the income stream that would arise from hypothetically operating that property. My Lord, I come on then to my Lord Justice Snowden's point, which is that we've seen there's no legal authority for the concept of transferable goodwill. The only source for that concept that the Upper Tribunal did or could refer to was, in my submission, didn't provide any support for its conclusion. So, in my submission, the only basis for the existence of that concept of transferable goodwill is GN1, and that was the guidance relied on by Mr. Ellis before the Upper Tribunal. And in my submission, the Upper Tribunal was wrong to rely on GN1 in the way it did for three short reasons, and I'll come on to show you the relevant bits of GN1 in a moment. The first point is obviously GN1 is RIC's guidance. It's not a legal authority for the existence of a concept of transferable goodwill. Second, even as non-legal guidance, the Upper Tribunal had noted and found that GN1 had been superseded by VPGA4 well before the Upper Tribunal hearing. And as I've already submitted, VPGA4 does not refer to the concept of transferable goodwill at any stage. It refers instead to trading potential. The Upper Tribunal held that, in my submission correctly, that it was appropriate to focus and refer to VPGA4 because that was the best practice, RIC's best practice at the time of the hearing. But then it effectively went on to base its decision on a concept that was found only in GN1. And in my submission, that's clearly a flawed approach to the guidance that it had before it. The clearest example of that is, just to show you briefly, is paragraph 114 of the decision. That's page 104. And if I could just ask you to read it, it starts on that page and just briefly goes over the page.
Sorry, I may have misunderstood. So page 104.
Sorry, yes, my lord, page 104, paragraph 114.
Sorry, right.
Well, what the Upper Tribunal does there is to quote at some length a passage from VPGA4, which refers to intangible assets. And then over the page, it says, well, the reference to intangible assets that are available to an REO, such as, we take the italicized passage to mean intangible assets that are available to the REO, such as the transferable goodwill referred to in GN1, can be reflected in the valuation of TRPs. Well, as we've seen, it's quoted VPGA4. There's no reference to transferable goodwill or to it being an intangible asset in VPGA4. All they've done is import a concept from the earlier guidance into the meaning of what they take to be of the later guidance.
But it's also a non sequitur, isn't it? If the transferable goodwill, whatever that is reflected in the valuation of the property, it doesn't follow that it's a separate asset when what is being valued is the property.
Indeed, my lord, yes. And perhaps leading on from that and coming on to the point that my Lord Justice Snowden made, the third reason why the Tribunal's reference to GN1 in my submission is clearly incorrect is that even on its own terms, GN1 is clear that the concept that it refers to as transferable goodwill is not an asset that's separate and distinct from the trade-related property as interested land. My Lord, that's the relevant definition there is the definition of transferable goodwill that my Lord Justice Snowden has already pointed to. My Lord, that is on page 201 of the supplementary bundle. My Lord, I must mention it's absolutely clear from that definition that even on the terms of GN1, transferable goodwill is inherent to the specialised property and will transfer to a new owner on sale. So in my submission, there's no basis whatsoever for the Upper Tribunal to have concluded that it somehow forms a distinct and separate asset of goodwill to which the agreed valuation should be attributed to. So to summarise then, the first 2 points, there's no legal authority for it. The only authority for its existence, in my submission, points directly to the opposite conclusion of what the Upper Tribunal arrived at. Third and final argument against the Upper Tribunal's conclusion on transferable goodwill is that in my submission, the attribution of the agreed valuations to a separate and distinct asset of goodwill on the facts of this case is contrary to the existing authorities that we do have on goodwill. Now, there are not a huge number of authorities, surprisingly, given the value of goodwill to the economy. But that is, in my submission, for 2 reasons. The first and lesser point is that here we, as we've seen, we're looking at a hypothetical business run by a reasonably efficient operator. Now, in my submission, by definition, that is the average business that could be carried on from the trade-related property. There is nothing to distinguish or differentiate it from any other business that would be carried on by a reasonably efficient operator from that property.
Well, the critical thing is it excludes personal goodwill.
Indeed, my Lord, yes.
And if you exclude personal goodwill, anything that's left must be inherent in the property. Where else do you get it from? Where else is it from?
Yes, my Lord. Yeah, absolutely.
What else is it?
Exactly. There's nothing special to this business at all. It's just what anyone reasonably efficient could derive from the land. And so that can't be attributable to
I've been supposing that the concept of transferable goodwill was really only used in contradistinction to personal goodwill, which is not transferable because it's personal.
Well, I think, my Lord, it doesn't quite go that far because I think in my submission, personal goodwill can transfer. So if we think,
well, yes,
you could have a brand,
doesn't transfer with the land.
Indeed, that's the point, that it doesn't necessarily transfer with the land, whereas what was referred to as transferable goodwill necessarily does transfer.
Personal goodwill can pass to a purchaser to the extent that the purchaser takes on the branding, particular people as part of the workforce.
Absolutely.
Yeah, your celebrity chef.
Sorry, my Lord.
Your celebrity chef.
Yes, indeed, my Lord. If the celebrity chef transferred, or if you had a brand that was let's say, to make it specific to a care home, let's say there was some particular brand that was well regarded in the care home industry, that could be transferred to a purchaser. That plainly would, using the distinctions we're relying on at the moment, be personal goodwill. That's in no sense inherent in the land.
And you would assign it to a purchaser. And normally the agreement would include, and I haven't looked at this one, but it would include clauses designed to protect that personal goodwill in the hands of the purchaser, such as
Restrictive covenants or something.
Well, yes, to prevent the vendor from setting up again just down the road and luring the people who were attracted to him or her away from the business that had been sold.
Indeed, my Lord, yes. So that the reference that I have to the Planet Art case is really just exemplifying a common sense point, which is that here we have a reasonably efficient operator. There is nothing to distinguish this hypothetical business. None of the brands, the people, none of the things that would be personal goodwill.
Well, and that's apparent from the definition you showed us of 2.10. The last few words make it clear that the definition of a reasonably efficient operator excludes personal goodwill.
Indeed, my Lord, yes. What I would say is that this point about there being nothing to distinguish it, actually the only thing that distinguishes this hypothetical business that we're looking at is the land itself. The only thing we really know is that it's run from this particular trade-related property. And it's the profits that can be generated by a reasonable, efficient operator from the property. And again, in my submission, that just simply goes to emphasise that what we're looking at here is the value of the land, not anything else. Well, that was the first point. The second, and in my submission, more fundamental point, is that it is incoherent to maintain that the agreed valuations are attributable to goodwill of a hypothetical business. And that's for the simple reason that the hypothetical business, by definition, does not exist. And in my submission, it's been clear for over 120 years that goodwill has to be attached to a particular business. And I think it may be the only authority we actually need to go to, but it's the Muller's margarine case. It's in the authorities Bible, tab 3. Now, my Lord, it's a 7-member panel of the House of Lords deciding the case. It concerned a foreign business where there was the sale of the premises and the goodwill. And as I like to think with so many important cases, it was a tax case. It's to do with the Stamp Act of 1891. And there were 2 issues. The first was the contract by which the business was transferred. Was that contract made in the UK? And their lordships unanimously held it was. That point's irrelevant for our purposes. The second question was, did the transaction or did the contract concern, quote, property locally situate out of the United Kingdom? And it was common ground that property could include goodwill. If it did relate to property that was located out of the UK, then that was an exception from liability under the Stamp Act. So really the case is concerned with the location of goodwill in circumstances where the business and all the customers were outside the UK. It does, however, contain what I'm sure are very familiar statements and the classic statements as to the nature of goodwill in English law. 6 of their lordships all held it was situate outside the UK, and so there was no tax liability. But the 2 key passages that get cited in essentially every subsequent case about the existence of goodwill are taken from Lord Macnaghten and Lord Lindley. So the Lord Macnaghten passage is in starts on page 14.
Yeah.
And my Lord, it's red line, so if I could just ask you to read that.
Just help me, would you, on the last part of the first paragraph on page 15. Lord Macnaghten says that to analyse goodwill and split it up into its component parts, as the Commissioners desire to do until nothing is left but a dry residuum in gain to the actual place, is not a good idea. And what the Attorney General seemed to be arguing, going back to page 10, was that goodwill falls under 3 heads. One, where the property has a natural advantage of locality, e.g. a shop at the corner of 2 thoroughfares. 2, whether from the reputation of the place is an established habit of customers to resort there. And 3, whether personal reputation of the trade has been acquired. Now, Lord Macnaghten is in effect saying that's not the way to do it.
That's right, my Lord. And again, we come back to this attempts that there have been made over time on the part of, well, here, HMRC, and it does go back a long way to try and break down and analyse goodwill into sort of different constituent elements. You see that also there's a case that gets referred to in the Upper Tribunal decision, the Whiteman case about the Landlord and Tenant Act, and that's the rat, the cat, the dog,
rat, yes.
Chicken, goodwill. In my submission, Lord Macnaghten's right. You shouldn't be trying to slice and dice it up. There is goodwill, which, as my Lord Justice Snowden said, is effectively a residual value over and above the value of of the assets in a business.
But going back to what the attorney's arguing, you would say, would you, that where the property has a natural advantage of locality is simply part of the property value? It's nothing to do with goodwill at all.
Absolutely, yes. That is my position, and HMRC's position now. And it's obviously this is a case from over 100 years ago. Valuation practice has very clearly moved on a long way, and that's why I say HMRC's position is effectively in line with BPGA 4 to say you're looking at trading potential. That isn't a species of goodwill at all. It just goes to the value of the property.
So in that sense, this case is against you. I mean, Lord Lindley also says that goodwill includes whatever adds value to a business by reason of, among other things, situation.
So it's against possibly my technical analysis, but what they all say is that generally, well, not they all say, I shouldn't say they all say, but there are aspects of a number of the speeches that say, well, there is goodwill that goes to the value of the asset. So they'll say often a pub, to some extent it's my Lord Justice Snowden's point, but you can say that this is inherent goodwill that generates value, but they are all clear that it goes to the value of the asset. It's not a separate, distinct asset that exists dissociated from the property.
Yeah.
My Lord, the second sort of locus classicus is Lord Lindley's analysis. That is page 26.
I have to say, just saying, speaking for myself, I'm not quite clear what Lord Norton was on about at page 224 in the start of the paragraph beginning before my part. I mean, I understand that goodwill has to attach to a business. That I understand. That's inherent in the very nature of the concept of goodwill. But for him to say that one attribute common to all cases of goodwill is the attribute of locality, I mean, that isn't the case with what is described as personal goodwill, is it?
Well, and that's actually the Lord Chancellor's analysis is to say, I really can't agree with you all. If there is this goodwill, it doesn't have a specific location.
But the problem is goodwill can consist of a number of elements. As we've just, I think that's the. I'm not sure quite what I get from this, especially when one looks at a valuation mechanism, which, on any view, does refer to personal goodwill.
Indeed, my Lord. I mean, my submission really, what I rely on is the point that I think, my Lord, you said you did agree with, that it is inherent in goodwill that it's attached to a business. It is a function of an existing business. And so it's Lord Macnaghten's statement, it cannot subsist by itself, it must be attached to a business.
Yes, because it is the attractive force which brings custom to the business.
Indeed, my
Which
Lord.
distinguishes, as he said at the top of the page, an old established business from a new business.
Indeed, my Lord. Well, my submission is that for an asset to be goodwill, it must be attached to an existing business. What the valuers here are doing is looking at some hypothetical business that doesn't exist, that would be run by an REO, ascribing value to that, and then what is being said against me is that value that's arrived at is a figure for goodwill. Well, in my submission, that isn't an amount that is attaching to an existing business. It's being generated purely by reference to a hypothetical business that could be run from the trade-related property. So that's what I rely on it for. Essentially the point that goodwill is, by definition, a facet of an existing business, the business on the ground. What you can't do is say, well, by reference to some other way in which the business could be run, here by a reasonably efficient operator, I've generated a value, and that value is attributable to the goodwill of my existing business. So my submission, that really gets to the point that I'm seeking to make, that what the Upper Tribunal has sought to do is to look at this hypothetical business, arrive at a value, and then say, well, that is a value for goodwill of the existing business in the care homes as at the date of valuation. And in my submission, that simply is inconsistent with the nature of what goodwill is.
And Lord Lindley is at page 26 of the bond, which is the other. That's the other passage you.
Indeed, in this wide sense, goodwill is inseparable from the business to which.
But immediately after the passage you've redlined, he talks about location.
Yeah, and the goodwill of a business.
Goodwill can have a distinct locality. Goodwill of a public house or a shop is an instance. The goodwill of a business usually adds value to the land.
Indeed, my lord. We come back to that attempt to sort of slice and dice. You have my submission, I think, that that's not the right way to look at it. The correct way to look at it now is that it's simply location, or if you have a high footfall, all those kinds of things are not aspects of goodwill. They are simply inherent aspects of the land.
Well, I suppose for the purposes of this case, any goodwill that attached to the situation of the physical business was always going to be in Germany, because that's where it was all carried on. So that was what they were concerned with, the location of goodwill, whatever it covered.
Indeed, my lord. Certainly
It's not the central part of this decision.
No, my lord. It's very clearly a case about location. My lord, in my submission then, this analysis of looking at a hypothetical REO and the value that can be generated by it provides no basis for saying there was existing goodwill in the actual business on the ground. And in my submission, that is in effect also a complete answer of principle to why the Upper Tribunal and where it went wrong. The correct analysis, I think picking up my lord's point, is instead that what valuers do is that they have regard to the forecast of the performance of the hypothetical business of an REO as a method of ascribing value to the property in question as an interest in land. And the reason they do that is because the value of the trade-related property, because it's specifically adapted to a particular use, the value of that property is inherent in what income, what profit you can generate from that use. And just to give a sort of practical example, my lord, just to show that the fallacy inherent in the Upper Tribunal's approach, if you imagine a care home business that was run very poorly, very unprofitably, so undercharging, overpaying for supplies and for staff, very poor quality of service. Now assume a reasonably efficient operator would generate a much higher profit level than the existing business that was operating. Now those potential profits, the trading potential, would lead potentially to a high valuation of the trade-related property. But the approach advocated by the respondents and adopted by the Upper Tribunal would attribute that high valuation to goodwill of the existing business. And I'd submit plainly that makes no sense. There is no goodwill in the existing business. In that example, the business is performing much worse than the reasonably efficient operator, which, as we've seen, is an average objective standard. And just to take that point slightly further, that example, in fact, reflects the facts of this case. Because it's here, in this case, it was agreed that the agreed figures for both FMT and FMOP were higher than the figures in the actual accounts of the businesses that were operating on the valuation date. So for your note, I don't propose to take you there, but the details of the figures are set out in Ms. Rodriguez's first report at paragraphs 12.8 to 12.14 and 13.7 to 13.12. And that's tab 3, page 145 to 6 and 147 to 8 of the supplementary bundle. That's the raw figures, but the easiest way to see that there was a substantial adjustment here is just to briefly look at the transcript. It's the cross-examination of Mr. Ellis, so the taxpayer's expert, and it's tab 9, page 226.
Page?
226, my lord. And it starts halfway down the page. I was pressing Mr. Ellis on how the figures for FMT and FMOP have been derived. So you see, question. Now you say it is to a degree driven by the actual business. Yes, and that means really it is the starting point, does it not? Yes, but you could end up adjusting it very significantly. And we have in this particular case. So really, the FMOP and FMT figures here do not really bear any relation to the actual figures on the ground. Do they? No. They are quite significantly higher. That is right. So this case is, in fact, the example I've just given. The figures of fair maintainable turnover and fair maintainable operating profit that an REO would generate are substantially higher than the figures that were actually being generated on the ground on the valuation date. And yet it is said that the businesses on the ground on the valuation date had very substantial amounts of goodwill. And in my submission, that plainly makes no sense.
Sorry, say that again.
So the figures of FMT and FMOP that were agreed, which represent what an REO would generate, were much higher than the actual figures on the ground.
Yes.
And so a standard operator would be operating the premises much more profitably.
Yes.
And so my submission is that in those circumstances, there wouldn't be goodwill in the businesses. They're operating less effectively, less profitably than an average operator from those premises.
It depends what you mean by goodwill. I mean, it just means that the person currently operating from those premises is driving people away. It's the bad pub landlord at my lord's past pub at the top of the hill. I mean, the people would love to come to look at the view, etc., but the landlord's a stinker.
Indeed, my lord. But my submission is that in that circumstance, in the market, in the open market, someone would want to buy just the land. They would want to say, I just want to buy the land. I don't want anything to do with your business because that's driving people away.
Well, I don't want anything to do with you.
Well, in the pub landlord case, that
pub,
probably is.
But it's just you're the problem because you're just an unfriendly so-and-so. But if I stick a couple of really nice people in here, people will come back to this place because it's a great place to come.
Indeed, my lord, but my submission would be that what you're identifying there is that the value of the land is what is driving the valuation, not anything to do with goodwill. Well, if anything, there's negative.
By goodwill, you see, I mean, if you, yeah, okay, all right, well, yeah, it's goodwill inherent in the property, which is being diminished by the negative goodwill, negative personal goodwill of the current operator.
But ultimately, it would go to whether one conceptualizes it as trading potential or as an inherent goodwill to the land. It still goes to the value of the land as an asset.
I know you just don't like this whole word, the word goodwill. I understand why you steer away from it.
I mean, you have my submission, Mother.
Yeah.
I mean, put shortly, if it's inextricable, you shouldn't extricate it.
Yes, my lord. It's part of the value of the land. Yeah. My lord, there is one point I should deal with briefly, which is the cold-warm start point.
Yeah.
And that, it's another part. We're going to come on to look at paragraph 110 of the Upper Tribunal's decision in a moment in relation to the market rent point. But the paragraph actually sort of divides in half, really, because the second half of the paragraph, it's page 104.
Yeah.
The tribunal says it's not the first or second sentence which relate to market rent, but the premium reflects the fact that the tenant is leasing a fully equipped operational entity, and from a business viewpoint is accepting a lower risk than having to start from scratch. That is a business advantage for which the tenant will be prepared to pay over and above the market rent. Now, my lord, that, for your note, reflects a summary of the debate that is recorded in the Upper Tribunal decision in paragraph 43. Now, that is in the section setting out the taxpayer's case. If you could turn to that, my lord, it's page
91.
91. If I could ask you to just read that paragraph.
Yes.
My lord, I should say that final sentence, it's slightly unclear what the Upper Tribunal is saying.
Well, that's Mr. Firth's submission, isn't it?
Well, that's what I take it to be, yes, because it's recorded in the context of the appellant's case. It's not said to be that, but that's what it appears to be. Now, to some extent, I've already just canvassed this issue, but in my submission is it's not correct because the business doesn't necessarily have value. To take the example of the pub that's terribly run, there, in my submission, the business itself that's currently operating has no value. It's the land with its inherent characteristics that have value. But that is the Upper Tribunal summarising the debate between the experts, the sort of cold versus warm start debate. And then that features into the actual reasoning of the Upper Tribunal in paragraph 110, in the paragraph we've just looked at. Now, my submission, that sentence in paragraph 110 doesn't provide any support for the Upper Tribunal's ultimate conclusion. The issue of a cold start versus a warm start was addressed by Ms. Rodriguez in her evidence, and it's put perhaps best in her report, her first report, which paragraphs 8.3 to 8.4. That's tab 3 of the supplementary at page 140.
Page
140, my lord.
Sorry, where page 1?
Sorry, page 140,
140.
my lord.
And paragraphs?
8.3 and then over the page on 8.4.
Right, thank you. Yeah.
Well, we also saw in VPGA 4, I don't propose to go back to it, but paragraph 7.1 and 7.2, that it says that an empty property can be valued by reference to its trading potential. My lord, in short, the answer to this point is that whether or not a care home is an operational entity on the date of valuation does affect the level of trading potential. So if it's operational, it's referred to as a warm start, the reasonably efficient operator would factor into its valuation the knowledge that there's a readily available market of customers and staff for the business to be operated by the REO, and the REO knows that it can generate fair maintainable turnover, fair maintainable operating profit more quickly. We also saw, the other consideration is that recent historical trading information gives greater certainty to an REO that it can know with a higher degree of probability as to what level of profit it's going to be able to generate. If something's been shut for a long time, there may be much more risk inherent in your assessment of the profits that can be generated by a reasonably efficient operator. And one final point, just to go back to VPGA 4, the definition of trading potential, page 213. Sorry, it's not 213. It's paragraph 2.13. It's page 209. We've already looked at this. It's the passage that says that trading potential reflects a range of factors that are inherent to the property. But you'll see one of those factors that are identified is trading history of the property within the market conditions prevailing. So the trading history is one aspect of the land that is a relevant factor that goes to the profits you can generate from it and therefore the value of it. Again, just perhaps to remake a point I've already made, but this analysis doesn't assume that the REO would purchase the existing business on the land. What it's saying is that it has more knowledge of the trading conditions. There is a market, that there are staff available, and more knowledge as to the historical performance. The REO on that basis could simply come in, buy the land, buy the desirable pub, buy the care home, and set up its own business. The relevance here is that the figure for trading potential that it would be operating on would be higher, and that is the relevance for Warm Start. One final point on that bit of the Upper Tribunal's analysis. It seems to say that the fact that a Warm Start is a business advantage means that it doesn't go to the value of the land. So it says that is a business advantage for which the tenant will be prepared to pay over and above the market rent. Well, in my submission, it's correct that it's a business advantage, but it does not follow that the value associated with that advantage is goodwill as opposed to the value of the land. Factors related to land are often business advantages. So a location on a high street with high footfall, an attractive view. Those are all things inherent to the land. They are business advantages, but they go to the value of the land because they increase the profit you could generate from that land. So well, that's the goodwill aspect of the Upper Tribunal's analysis. In my submission, the Upper Tribunal's conclusion that the agreed valuations relate to transferable goodwill as an asset that's separate and distinct from the leasehold interests is unsupported by any legal authority. It's contrary to the terms of the only document that actually refer to transferable goodwill. And in my submission, it's also contrary to the analysis in Muller that goodwill must be attached to an existing business. This, in my submission, is the most fundamental error in the Upper Tribunal's decision, because once it's recognised that there's no separate asset of transferable goodwill to which the agreed valuations can be attributed, the only other possibility is that that value is attributable to the leasehold interests. In my submission, it is an error of law that the Upper Tribunal has fallen into, and it is sufficient without more to allow this court to set aside the Upper Tribunal decision and to remake the decision on the basis that the agreed valuations are attributable to the leasehold interests. Nonetheless, there is this second strand of the Upper Tribunal's reasoning, the market rent point, and it is the point that my learned friend now relies principally on, so I do need to address that point. I've done so in paragraphs 44 to 54 of the skeleton, and in my submission, the Upper Tribunal's analysis in this context is really found in paragraphs 107 to 111. My lord, as you pointed out, paragraph 109, it sort of tees up the question and says, well, there's a premium, but what's it for? And then in 110, it purports to answer that question. So my submission, the key finding in this regard is the first two sentences of paragraph 110. So the Upper Tribunal says, in our judgment, the agreed market rent must fully reflect the trading potential available to the tenant under the terms of the 5-year lease, which it was granted. If that were not the case, as the appellants argue, it would not be the market rent, but something else. Now, my submission, that really is the Tribunal's reasoning on this point. There's not really any further exposition of why it's a market rent, how they arrive at that conclusion, or why that leads necessarily to the conclusion that it has no value. But it does seem to be, the analysis seems to be, point one, the experts agreed that this was a market rent, and it records that as we saw in paragraph 10 of its decision. And then, because the experts have agreed that, it follows that the leasehold interest can have no further value. and therefore the agreed valuations are attributable to this other asset that's identified transferable goodwill. Now, in my submission, no reasonable tribunal could have arrived at that conclusion on the basis of what was before the tribunal. And I've set out in paragraphs 48 to 54 the three principal reasons why, in my submission, the Upper Tribunal conclusion was untenable. The first point is that in my submission it misunderstands or fails to take account of what the experts actually said. Both the actual agreement between the experts, effectively in the joint statement, and also the evidence of Mr. Ellis in cross-examination. So the experts did agree that the leases provided for an annual market rent. Now that, it's footnote 20 of my skeleton provides the references, but in effect what the experts agreed was that the annual rents provided for in the lease were within the range of 35 to 50% of FMOP. And that was, albeit at the lower end, that broadly reflected market practice. The references are there in the footnote. I don't propose to go to them, but that's the reference to Ms. Rodriguez's report and also the cross-examination on the point. But in my submission, it's clear the experts did not agree that such a rent prevented the leasehold interest from having any further value for which the purchaser would pay a premium. So we see that very clearly from Ms. Rodriguez's evidence. If we look first, well, it's principally in her first report. So that is in tab 3 of the supplementary bundle. First of all, paragraph 15.6, which is on page 149. You'll see that Ms. Rodriguez refers to paragraph 9.4.1. That is back at page 141. Starting at the bottom of that page. I can ask you to read that as well and then read the page.
Yeah.
So, my lord, Ms. Rodriguez's position was very clearly and expressly that the leasehold interest did have additional value in the open market and that buyer would pay a premium for that amount. I'd note in that context, obviously, that an arm's length consideration for a leasehold interest can involve annual rent or a premium or both. So there's nothing conceptually wrong with Ms. Rodriguez saying, well, you could have an annual amount of rent plus a premium. And clearly, Ms. Rodriguez's position was that in this case, an arm's length arrangement would involve both an annual rent and a premium. So that's Ms. Rodriguez's evidence. In my submission, it's also clear that Mr. Ellis understood that to be Ms. Rodriguez's position, and we can see that clearly from the cross-examination in the transcript. My lord, if we could go to tab 9 of the supplementary bundle, page 241. Well, this is a slightly longer section. If I could ask you to read on page 241 from the penultimate paragraph, so we are in a situation, which is part of what's recorded as a very long question of mine, over the next page and then on to page 243, down to line 12, where it's the third answer on that page.
On 243?
Yes, my lord. So, my lord, I've summarised in the skeleton of paragraph 49 the 5 propositions that I take to have been established in that cross-examination. The first is that there are 2 instances where a purchaser of a leasehold interest in a care home might pay a premium. The first is where there's a profit rent, that is, where the annual passing rent is below a market annual rent. And the second is in relation to the trading potential in the property. And that's really the first bit on 241 down to 3/4 of the way down 242. Second, the agreement between the experts that the leases were subject to a market rent related to the annual rent provided for in the leases. And what the experts were agreeing was that there was no profit rent in this case. And that's the question. So it is, as we say, it is within the range that you would expect. Third, it was possible to have a situation where a lease is subject to a market annual rent, but there would still be a value that a purchaser would pay for in the form of a premium. So that's the section starting on page 242. But the fact that there is no profit rent does not necessarily mean there is no trading potential. Is that right? And that goes over the page to the second line that the purchaser would pay for in the form of a premium. Point 4, in agreeing that the leases were subject to a market annual rent, Mr. Ellis did not understand Ms. Rodriguez to be agreeing that the leasehold interest had no further value for which a purchaser would be prepared to pay. That's the next question. So in agreeing with Ms. Rodriguez on page 243. And then 5, the situation in this case is that the experts agreed that 1, the leases are subject to a market annual rent, but 2, a purchaser of the leasehold interests would also be prepared to pay a premium to acquire them, and consequently the debate is about what that premium relates to. So there was no debate between the experts that a purchaser of the leasehold interest would pay a premium. As we've seen, the only debate between them was what that premium was attributable to. Was it goodwill or was it the leasehold interests? So my submission, in light of the evidence before the Upper Tribunal, it wasn't open to the Upper Tribunal to simply conclude, well, the experts have agreed there's a market rent, therefore it must follow that there's no value in the leasehold interests. Can't simply glibly say that. So we have to scratch beneath the surface of that somewhat.
Well, is that right? I mean, Mr. Ellis, in the passage from the cross-examination that you showed us, is agreeing that in theory there could be something. He's also agreeing that he understood Ms. Rodriguez's position, but he's not agreeing with her.
Well, what he's agreeing is that there is amount payable in relation to trading potential. That there could,
or as he wants to call it, business goodwill.
He does want to call it business goodwill, yes. But it's agreed that there is a premium payable in respect of this purchase.
Yes, and as you rightly say in your skeleton argument, the question is what it's paid for.
Indeed, my lord, yes. All I'm seeking to establish there is that you can't simply say, as it might seem intuitively attractive to say, well, the experts have said market rent, therefore it follows that there's no additional value. Because at the very least, it's absolutely clear from Ms. Rodriguez's evidence that that's not what she's saying. So it's not, the question can't be settled simply by the experts' agreement. My lord, the second point, and a point of lesser importance, but one that I would still draw the court's attention to, in my submission, the Upper Tribunal's conclusion is also undermined by the only evidence that there was as to comparator transactions. Now, both experts agreed that it's very rare to have leaseholds of care homes, and that consequently there were few examples of comparator transactions. And Ms. Rodriguez was in fact the only person to identify any comparator transactions. Those are addressed in her report, and first report, and then in the appendix. So the bit of the report dealing with it is paragraph 16.9 to 16.10, and that's on page 150 of the supplementary bundle.
This is a sort of Edwards and Bairstow attack, is it? Only true and reasonable conclusion on the evidence. Is that the way you're putting it?
Yes, my lord. There is no.
We've been given Georgiou, and not to pick cherries, not to cherry pick evidence.
Indeed, my lord. Yes. This is the only evidence of comparables that was before the tribunal. So it's paragraph 16.9 and 16.10. And then, my lord, the appendix that's referred to, Appendix 9, is at page 162. And these are the example transactions that Ms. Rodriguez identified, or comparative transactions. The first three were all sales of leaseholds involving a premium that was recorded at the land registry. And then there are 4 examples of asking prices for care homes, where there was both a premium payable and a rent. Now, Ms. Rodriguez was careful to say in her evidence that, there are very few examples. These are the only examples I've been able to find. This is the information we have.
But what does it show? I mean, unless you analyse the rent and do the full profits valuation for each of the comparables, you have no idea whether the passing rent is or isn't the market rent for a start.
Well, what it does show is that in this particular market, where we know, and it's common ground, there are very few transactions, it's not unusual to have both a premium and a rent.
Yes, but,
An annual.
But it's common ground that if the rent is less than the market rent, then there is room for a premium. So simply to say, well, here are a whole bunch of transactions, which I see Ms. Rodriguez says are largely between connected persons, in which a premium has been paid, doesn't really tell you very much.
Well, I agree. It's certainly not a determinative point at all. I would simply say that it does show that it might seem immediately, intuitively unattractive to say there's a market rent plus an additional premium. What this is showing is that in the market, to the extent there is a market for these things, it's not unusual to have both an annual rent and a premium. Now, you're right, we can't interrogate the level of rent and say it's a market rent, but it's just showing that the structure of that Ms. Rodriguez's analysis is not in some sense unusual. The Upper Tribunal didn't address those at all. Now, it could have said, we can't interrogate them, we can't get underneath the nuts and bolts of it, but it didn't analyse them at all. But the more important and third point in my submission is that the Upper Tribunal's finding doesn't make sense from an economic perspective, but it's also incorrect on its face as a statement. So we've seen that both leases involve a passing rent of about 35% of FMOP. It's slightly more than that, but for our purposes, 35. And it follows that the experts agree that an REO, as a purchaser of the leasehold interest, would expect to retain 65% of FMOP as profit after rent. That's clearly it is a very significant level of profits during the term of the lease. And that the purchase of the leasehold interest would give a purchasing REO the opportunity to generate those profits. So just to take the example of Manor Place, you have a figure there of FMOP after rent of $405,000, a 5-year lease. So assuming the lease runs to course, the total expected profits of the REO over the course of the lease would be 2.025 million. HMRC's position is that a purchaser in the open market, assumed to be an REO, would pay a significant premium to acquire the opportunity to generate those profits. And similarly, that the vendor would require a significant payment to forego the possibility of generating those profits. And as we've seen, the experts agreed that there was a premium value attached to the care homes of £730,000. Now, the respondent's position is that there'd be no premium payable at all in respect of this profit-generating opportunity. And in my submission, that economically makes no sense. But it also shows that the actual premise of what the tribunal said in paragraph 110 is wrong. Because we've seen that the agreed valuations represent trading potential. And if we look at paragraph 110, in our judgment, the agreed market rent must fully reflect the trading potential available to the tenant under the terms of the 5-year lease, which it was granted. Well, that's simply not correct. Both experts have agreed that a premium would be payable in respect of additional trading potential. In effect, the amount of FMOP after rent. So my submission, just the factual basis of paragraph 110 is not sustainable. Now, a last point that I should address in that context, because it goes to an argument that's put against me in relation to this argument, is it is said that HMRC's case in this regard would entail that a purchaser of the leasehold interest should be paying an annual rent equal to FMOP. It said, well, my case somehow entails that the annual rent should be equal to FMOP, in effect paying away the whole of the expected profits over the course of the lease. And that's relied on at numerous points in my Land and Friends skeleton. It's paragraphs 50 to 60, 65 to 66, and 108 to 109. Now, the argument correctly notes that HMRC's case is that all of the trading potential must be attributed to the land interest. So I accept that. The trading potential is attributed to the land interest. And we've seen the definition of trading potential where it says it is inherent to the property. It's also correctly said, by my learned friend, that trading potential is the future profit of an REO, which numerically is equal to FMOP. And I accept that. But it incorrectly, in my submission, proceeds to assert that HMRC's case is that the landlord is entitled to all of the future profit that a person operating a business would expect to generate, and that consequently the market rent should be equal to FMOP. But in my submission, that is a non sequitur. That fails to take account of the point that I've made in my skeleton and I raised earlier, fails to take account of the significance of the year's purchase multiplier that's adopted here. We've seen that the year's purchase figure used is 2.125 in respect of a lease that is of at least 5 years length. And we addressed earlier that both experts proceeded on the basis that there was a reasonable prospect of continuance as well. But just assuming a 5-year lease, the YP figure is substantially less. So consequently, the agreed valuations, which are arrived at by way of FMOP after rent times 2.125, do represent a division of the trading potential of the leasehold interests between the landlord and the tenant. In effect, the tenant is getting 2.875.
I don't understand that. What you are envisaging here is a hypothetical sale of the lease to another. You're not, or at least not necessarily, envisaging a hypothetical surrender to the landlord. So why is the landlord getting anything?
Sorry, my lord.
The transaction is going to be typically between the tenant and an assignee of the lease.
That's absolutely true, and there is some confusion, and we sometimes descended into this in the Upper Tribunal. We are talking about, though, the value of the leasehold interest and how much, because we're looking at the transactions that took place in March of 2011, we're looking at how much additional value, in effect, the tenant would have had to pay, so here MPL and MHL, would have had to pay to get these leasehold interests. But you're right, sir, my lord, that is also functionally the same as saying a sale to an unconnected third party. Right. So yes, that's right, my lord. The point I make is simply that HMRC's case is not that the tenants would have been required to pay away the whole of the profit that they're generating over the course of the lease. Obviously, that would make no sense. It is a capitalised amount representing trading potential, and that amount was expressly said to reflect the risks and rewards for that property and the timing of those risks and rewards as well. And we can see that clearly in Ms. Rodriguez's evidence. If we go to the transcript, it's tab 9, page 268. So this is, this is my examination in chief of Ms. Rodriguez. Can you explain what factors you take to be relevant in arriving at the correct YP figure? Yes, so the YP figure is multiplied against the FMOP, and it in considering what multiplier to use, it reflects the risks and rewards for that property and the timing of any of those risks and rewards as well. So it's the risk inherent in the income stream and also when you are going to receive the income. In my submission, that's clearly dividing the residual trading property as between the premium payer and the premium recipient. It's not suggesting that all of the residual operating profit is being paid away by the tenant. In short, what that argument does is to mischaracterise HMRC's case by jumping from the correct assertion, which is that HMRC accept that all of the trading potential is located in the land, or the value attributable to it is located in the land, to the incorrect assertion that HMRC's case is that the landlord would necessarily get all of that amount. Obviously, in an arm's length transaction, there's a negotiation to divide up that amount of fair maintainable operating profit. My Lord, turning then to the consequences of the Upper Tribunal's errors of law, I think you already have my submission. My submission made these two errors of law: one, ascribing the value to transferable goodwill; secondly, saying that the market rent fully represented the trading potential available to the tenant. My submission: if you find that those are errors of law, it must necessarily follow that the agreed valuations do relate to the leasehold interests. And I'd note that that's entirely consistent with how the experts actually described the agreed valuations as in fact relating to the leasehold interest. Yeah. But on that basis, I would therefore ask this court to set aside the decision of the Upper Tribunal and remake the decision on the basis that the agreed valuations represent the leasehold interests. My Lord, may I have a moment just to check?
Yes, of course.
I just want the reference for 121, paragraph 121.
My Lord, unless I can assist further.
I think Lord Justice Snowden has a question for you.
Just got one question. In paragraph 121 of the Upper Tribunal's decision, they said that we think Mr. Ellis was right to say his valuation wouldn't have been different whichever guidance he'd relied upon, because in either event, business goodwill was included as part of the trading potential. Is there a reference to that somewhere? They included a reference to what Mr. Rodriguez had said previously. What's the reference there, and to the expression business goodwill? Is that what Mr. Ellis said, or is that their interpolation of what he said?
So I take it that that's a reference to his cross-examination. I don't have the passage immediately to hand, but I can find it. There's no concept of business goodwill defined in the guidance they were looking at, as we've seen, this personal goodwill. Mr. Ellis did say in cross-examination that he would have done the valuation the same both ways, and it was his case that the valuation represented business goodwill, or it was his evidence.
I'm trying to understand what concept of business goodwill. Did he give an explanation as to what the concept of business goodwill was? It's not anywhere else, I don't think.
Not that I'm aware of, but perhaps that might be something my learned friend could pick up. But okay, not that I'm able to point to, my Lord. I mean, what I was putting to him was that in effect VPGA 4 doesn't provide for transferable goodwill, and if you would have got to the same result under GN1, it goes the other way. In other words, it's not goodwill because there's no reference to goodwill. What he was saying was, well, no, I would still say it was goodwill because under GN1 it was referred to as transferable goodwill. But, my Lord, as you've seen, that's transferable goodwill, not business goodwill. Well, unless I can assist further.
No, thank you very much.
Great for now.
Well, Mr. Firth, shall we start at 2 o'clock? That gives you enough time?
Yes, my Lord.
All right, 2 o'clock.